The jury that convicted Alex Murdaugh of murdering his wife and son deliberated for just 45 minutes. Not because the case was simple, but because a 53-second Snapchat video recorded at a dog kennel moments before 2 people died had already done what 11 years of financial crime could not. It placed him at the scene, in his own voice, calling for a yellow Labrador named Bubba. March 2nd, 2023. Colleton County, South Carolina. A courtroom that had absorbed 28 days of testimony, forensic evidence, financial records, and grief. 28 days. And then the jury walked out, and 45 minutes later, they walked back in. To understand how quickly that happened, you have to understand what it usually takes. The average felony jury deliberation in the United States runs somewhere between 4 and 24 hours. Complex white-collar cases can stretch for days. Murder trials, with their burden of proof and their weight of consequence, tend to generate long, careful deliberation because the stakes demand it, because reasonable people disagree, because uncertainty is the texture of these decisions. 45 minutes is not deliberation in any conventional sense. 45 minutes is confirmation. It is 12 people sitting down in a room, looking at each other, and arriving at a shared conclusion they had already privately reached somewhere in the preceding weeks. The trial had been, by any measure, dense with competing narratives. Alex Murdaugh's defense team had constructed an alternative universe of shadowy third-party suspects, forensic ambiguities, and a grieving father too destroyed by loss to have committed the acts he was charged with. They had challenged ballistics, questioned timelines, and presented Murdaugh himself on the stand, a decision that carried enormous risk, and as it turned out, enormous consequence. None of it moved the needle for 45 minutes. What the jury had seen, before any of the legal argumentation, before the expert witnesses, before the closing statements, was 53 seconds of video recorded on a phone by a 22-year-old man who would be dead within the hour. Paul Murdaugh filmed the video on his Snapchat account at approximately 8:44 p.m. on the evening of June 7th, 2021. The location was the dog kennels on the family's 1,770-acre hunting lodge known as Moselle in Elanton, Colleton County, a property whose very scale spoke to a particular kind of inherited wealth and authority in rural South Carolina. The video is casual, unremarkable in the way of most social media content. Flickering light, the ambient sounds of animals, the loose and careless framing of someone not thinking about posterity. What it captured was a family. Specifically, it captured voices. Paul can be heard greeting his father. "Hey, Dad." Those 2 words carried the entire weight of the prosecution's case against Alex Murdaugh, because for the first 18 months of the investigation, Alex had told law enforcement he had not been at the kennels that evening. He had told them he went to visit his ailing mother after dinner. He had told them, with the practiced fluency of a man who had spent his career persuading people, that he was elsewhere when his wife and son were shot to death. The video said otherwise. Maggie's voice is also audible in the footage. She can be heard calling out for Eddie, a reference to the family's caretaker Eddie Smith. Her voice is ordinary, unhurried. There is nothing in the recording that suggests distress or awareness of danger. She's simply a woman at a dog kennel on a summer evening calling out a name, existing in the last documented moments of her life, with the casual ease of someone who expects tomorrow to come. And then, beneath the ambient noise, slightly off camera but unmistakably present, a man's voice calling for the family's yellow Labrador by name. "Bubba. Come here, Bubba." That voice belonged to Alex Murdaugh. Audio analysis would later confirm it. Witness testimony would corroborate the identification. And one juror, speaking afterward about the deliberation process, was precise about the moment the case resolved itself. "I don't know him, so I never knew his voice, but I realized it was him in the kennel video, and that just kind of sealed the deal. Sealed the deal, not complicated it, not raised it to a new level of consideration, sealed it." That phrase is worth sitting with for a moment, because it tells us something about how the human mind processes evidence, when a central lie has been exposed. For months and then years, Alex Murdaugh had built a specific narrative about where he was and what he did on the evening of June 7th. He had looked investigators in the eye and maintained it. He had constructed his innocence around a geographical alibi. Not there, not at the kennels, not present when the shots were fired. The video did not merely contradict that alibi, or it demolished the architecture of his credibility. Once the jury understood that he had lied about something as specific and verifiable as his location 12 minutes before 2 people were murdered, every subsequent claim he made, every alternative theory, every expression of grief, every insistence of innocence, had to pass through the filter of that established lie. Very little survived the passage. During closing arguments, Prosecutor John Meaders paused in his reconstruction of the evidence, and he said 2 words that became the unlikely moral punctuation of the entire proceeding. God bless Bubba. It was a line that could have come across as glib, but in context it landed precisely. Because the yellow Labrador hadn't known he was evidence. He had simply been at the kennel, and someone had called his name. And 22 months later, that call would end a trial in under an hour. The defence had done everything it could to neutralise the video. They questioned the voice identification methodology, emphasised the limitations of ambient audio captured on a phone, and argued that the recording alone could not establish a timeline tight enough to implicate their client in the subsequent deaths. These were not frivolous arguments. Voice analysis has known limitations. Ambient audio can be misinterpreted. Juries are instructed to apply scrutiny, not sentiment. But the jury had also watched Alex Murdaugh sit in the witness box and acknowledge, in his own words, that he had lied. Not once. Not as an isolated error in the chaos of grief. He had lied repeatedly, systematically, and he had continued lying after each individual lie was identified. And when he tried to explain that pattern, when he reached for an exculpatory framework that could make sense of it, he quoted, of all things, Sir Walter Scott. "Oh, what a tangled web we weave," he said from the stand, and then added with an almost clinical precision, "I meant when I lied, I continued to lie." That moment is unusual in the annals of criminal testimony. Most defendants who take the stand work hard to minimise their admissions, to frame each concession as an isolated exception rather than a defining characteristic. Murdaugh did the opposite. He described lying as a habitual, compounding behaviour, something triggered by paranoia and sustained by the momentum of prior deception. His explanation centred on opioid addiction, the disorganised thinking, the irrational self-protection, the fog of withdrawal and dependency. It was a genuine attempt to offer context, but context and exculpation are not the same thing, and the jury appeared to understand the difference. What makes the kennel video so forensically decisive is not just what it proved, but what it foreclosed. Before the video's existence became publicly known, the defence had the theoretical room to argue that Alex was an innocent man navigating an impossible investigation, that his distance from law enforcement was the natural caution of a lawyer, that his grief was real and his ignorance genuine. The video collapsed that theoretical room to almost nothing. It transformed the question from "could he have done it?" to "why did he lie about being there?" And in 28 days of trial, no answer to that second question emerged that the jury found persuasive. There is something almost geometrically strange about the proportionality of it all. 28 days of proceedings, hundreds of exhibits, testimony from dozens of witnesses, forensic pathologists, financial investigators, law enforcement officers, family members, a defense team executing a sophisticated strategy against a prosecution backed by the full weight of a case that had occupied South Carolina's law enforcement apparatus for nearly 2 years. And at the end of it, the decisive instrument was 53 seconds of phone video, shot by a young man to document a visit to some dogs, capturing the voice of his father calling a name into the dark. 45 minutes. The question that opens from this verdict is not really about guilt. 12 people resolved that with the kind of swift consensus that only clarity produces. The question is about the distance travelled to arrive at that courtroom. How does a man who occupied one of the most powerful positions in one of South Carolina's most entrenched legal families end up sitting at a defendant's table while a prosecutor invokes the name of a Labrador retriever as the closing argument in a double murder case? How does a man who practiced law for decades, who knew every procedural mechanism and institutional relationship that the law provides, end up unable to explain away a recording his own son made? The answer is not simple. It involves money, staggering amounts of it, moved over more than a decade in ways that required ongoing concealment and compounding deception. It involves deaths beyond the two in this case, deaths that preceded the murders and that investigators and journalists were still working to understand even as the verdict came down. It involves the specific weight of institutional power in small, close-knit communities, where the law is not merely a profession, but a hereditary identity, where the family name on a door has meant something for generations, and where that meaning can, over time, become a mechanism for evading the very accountability the law is designed to enforce. The 45-minute deliberation is not the beginning of this story. It is not even really the ending. It is a single concrete point of closure in a case whose edges extend outward in multiple directions, into deaths that were never properly examined, into financial wreckage spread across dozens of victims, and into a legal profession in one state that was forced to confront what it had permitted to exist in its midst. But it is the right place to start, because in that courtroom, in that astonishing brevity of decision, you can hear the sound of an alibi finally running out of room, and somewhere underneath the legal procedure and the forensic testimony and the financial records and the grief, you can hear a man calling a dog's name and understanding, even if he didn't know it yet, that the sound had carried further than he'd planned. To understand what Alex Murdaugh was before he became what the verdict said he was, you have to stand still in Hampton County, South Carolina for a moment and let the geography do its work. Hampton County sits in the low country of South Carolina's coastal plain, a place of long flat roads, pine forests, and Spanish moss that drapes itself over everything with a patience that feels almost biblical. The county seat, the town of Hampton, has a population that has never pushed much past 3,000 people. There are churches, a courthouse, a diner, the particular social geometry of a place where everyone knows not just your name but your grandmother's name, and the land your grandfather sold and the judgment your cousin fought 20 years ago. These are communities where history is not academic, it is operational. It shapes who answers the phone and who gets the call in the first place. In communities like this, certain names accumulate a weight that no single generation could build on its own. The Murdaugh name was one of those. For roughly a century, the family had occupied the office of solicitor for South Carolina's 14th Judicial Circuit, the chief prosecutorial authority for a region encompassing 5 counties in the southern part of the state. That is not a record of individual achievement. That is a dynasty, in the plainest and most literal sense of the word, a succession of power transmitted along family lines across multiple generations, woven so deeply into the institutional fabric of the circuit that the name and the office had become, in the minds of many who lived there, nearly synonymous. Alex Murdaugh's grandfather, Randolph Murdaugh Sr., held the solicitor's office. His son, Randolph Murdaugh Jr., held it. Randolph Murdaugh III, Alex's father, known locally as Randy, held it as well. 3 generations of the same family occupying the same prosecutorial seat, as across decades that spanned the New Deal and the Civil Rights Movement and the war on drugs and everything in between. By the time Alex came of professional age, the Murdaugh family had not merely participated in the legal system of the 14th Circuit. In a real and documented sense, they had been the legal system, or at least the most visible and durable expression of it. This is the world Alex Murdaugh was born into. Not born adjacent to, not born aspiring toward, born inside. The courthouse was not an institution he would one day earn his way into. It was, in the most visceral sense, home ground. He became a civil attorney rather than a prosecutor, channeling the family's authority into private practice at Peters, Murdaugh, Parker, Elsroth and Dietrich, the firm known throughout the region by its initials PMPED. The firm itself was deeply enmeshed in the community it served, handling the kinds of cases that define the legal texture of rural life: personal injury claims, wrongful death suits, property disputes, the slow financial reckoning that follows accidents and negligence and loss. Its clients were often people with limited resources and nowhere else to turn, people who came to the firm because the firm was what the region had, and because the Murdaugh name on the letterhead carried a presumption of capability and integrity that generations of civic proximity had built. Alex was a partner. His position at PMPED was not incidental to the family legacy. It was its most current expression, the form the dynasty took in his particular generation. He moved through the professional landscape of the Low Country with the ease of a man who had never been required to establish his credibility from scratch, because his credibility had been pre-established before he walked through any door. Judges knew the family, law enforcement knew the family, opposing counsel knew the family. The informal networks of professional deference that operate in every legal community, the phone calls that get returned, the accommodations that get made, the assumptions about good faith that smooth the friction of the legal process, all of those networks ran through the Murdaugh name in the 14th Circuit in ways that no outsider could fully map. And then there was the land. The Moselle property, 1,770 acres in Islington in Colleton County, is the physical expression of everything the name had accumulated. 1,770 acres. To put that in perspective, the average American farm is approximately 445 acres. Moselle was a working hunting lodge, a private compound, a piece of the low country terrain so large that it constituted its own geography. It had its own name. It had dog kennels, outbuildings, a residence, land that extended further than a person could walk in an afternoon. It was the kind of property that does not get purchased. It gets inherited piece by piece, generation by generation, the way power accumulates in places where the same families have controlled the same resources across the same decades. When prosecutors and journalists and documentary filmmakers later struggled to explain how Alex Murdaugh had operated so freely for so long, they kept returning to the land, not as metaphor, or not only as metaphor, but as evidence of the material weight behind the name. A man with 1,770 acres and 3 generations of prosecutors in his family tree occupies a different structural position in a 5-county rural circuit than any description of individual personality or professional skill could account for. The land is the inheritance made visible. It is the reason, before any crime was committed or any fraud perpetrated, that certain questions did not get asked, because the person those questions would have been asked of had a particular kind of standing in the community that made the asking feel, to some, almost impolite. This is the mechanism that scholars of institutional power describe when they talk about how concentrated authority insulates itself. It is not that wrongdoing is explicitly protected by allies. It is that the accumulated weight of reputation and relationship creates a friction against scrutiny that most institutions, grand juries, licensing boards, professional oversight bodies, are not structurally designed to push through without a specific and undeniable precipitating event. The 14th Judicial Circuit had that friction in abundance. Think about what it would require in a county of 3,000 people to be the person who formally questioned the conduct of a man whose grandfather had prosecuted cases in that county before your parents were born. Think about the professional exposure of being the opposing attorney who raises misconduct allegations against a partner at a firm whose name appears in the county's legal history going back decades. Think about the position of a client who suspects something is wrong with how their money has been handled, but who received that money through a settlement arranged by a lawyer whose family name is on the courthouse steps, figuratively if not literally. The social and professional costs of accusation in that context are not imaginary. They are real, and they compound over time, and they explain why an 11-year pattern of financial misconduct could persist without formal action until the moment it became too large and too documented to contain. The family's legal authority also created an unusual relationship with law enforcement in the circuit. When you are the family that has prosecuted crimes in a region for a century, your personal relationships with investigators, deputies, and officers are not peripheral. They are structural. The Murdaughs knew law enforcement in the 14th Circuit the way any long-tenured institutional family knows its professional neighbours, through shared history, professional interdependence, and the kind of trust that accumulates through decades of working proximity rather than through individual evaluation. That trust was not improper in itself. Most of it was simply the ordinary product of institutional longevity. But trust of that depth, operating in a context where accountability was already attenuated by professional deference, creates conditions where oversight slips into a different register, where questions that would be asked of a stranger are not asked of a neighbour. That is not a conspiracy. It is something more mundane and in some ways more dangerous. It is the ordinary behaviour of institutions operating within their habitual patterns shaped by generations of a particular family's presence when confronted with evidence that the family may not be what it appeared to be. In the aftermath of conviction, South Carolina attorneys who reflected publicly on the case chose their words carefully. But the message was consistent. Alex Murdaugh, one attorney said, had really done great harm to the legal profession in South Carolina. That framing is worth examining closely, because it locates the harm not just in the individual crimes, the fraud, the theft, the financial ruin of clients who trusted him with their most desperate circumstances, but in something more diffuse and harder to repair, the damage to the professional reputation of a system that had permitted a man with his record to operate unchallenged for more than a decade. That acknowledgement was not comfortable for the South Carolina legal community to make. It required a kind of institutional self-examination that professions do not undertake willingly, because it means admitting that the mechanisms designed to prevent this kind of damage had failed. Not dramatically, not through corruption in the traditional sense, but through the quieter failure of deference, of assumption, of a collective willingness to extend trust to a name rather than require accountability from a person. The legal profession in South Carolina had not invented Alex Murdaugh, but it had, in the most direct and documentable sense, provided him with the conditions in which he could operate for as long as he did. The firm, the family, the circuit, the land, each of these was a layer of the same structure, and together they formed something that functioned not as a conspiracy, but as a system whose ordinary operations, whose unremarkable daily workings, had made extraordinary misconduct possible for over a decade. What makes this history so important to the murders of June 7th, 2021, is not that the dynasty caused the murders in any simple causal sense. It is that the dynasty shaped the context in which everything preceding the murders became possible. The financial crimes that put Alex Murdaugh under irrecoverable pressure by the summer of 2021 were not the product of a single bad decision or a moment of desperation. They were the accumulated result of years of behaviour that the institutional structure of the 14th Circuit had made survivable, years during which the normal corrective mechanisms of the legal profession had encountered the weight of that name and, with some exceptions, stepped aside. By 2021, Alex Murdaugh was the last male heir of the dynasty in active practice. His father Randy had retired. The family's century at the prosecutorial helm of the circuit had ended. The institutional weight was still there, in the land, in the professional relationships, in the community memory of what the name had meant. But the formal authority that had anchored it was receding. And in that space between the inherited weight of the past and the compounding pressure of his financial exposure, something had been building for a very long time. The 45 minutes the jury needed to reach its verdict were, in a meaningful sense, the product of everything that came before the trial. Not just the evidence presented in the courtroom, but the decade-long dissolution of the conditions that had once made Alex Murdaugh untouchable. The kennel video ended a specific lie. But it was the collapse of a much longer structure that put him in the courtroom in the first place. There is a particular kind of theft that does not announce itself. It does not arrive as a single dramatic act. No vault cracked open, no wire transfer traced to a foreign account in one clean line. Then it accumulates the way water damage accumulates inside a wall, invisible for years, structurally catastrophic by the time anyone sees the surface change. What Alex Murdaugh did to his clients and his firm over 11 years was that kind of theft. Quiet, patient, repeated, hidden in the ordinary machinery of legal practice, where money moves through accounts with the regularity of breathing, and the people whose money it is rarely have the expertise to track exactly where it goes. The scope, when it finally came into view, was staggering. Investigators and prosecutors ultimately documented that Alex Murdaugh stole approximately $8.5 to $10 million from clients and from PMPED over a period beginning around 2010 and continuing through 2021. 11 years. The number matters not just for its size, but for its duration, because 11 years is not a crime of desperation or impulse. It is a practice. It is a methodology, refined over time, embedded in the daily operations of a professional life. It means that for more than a decade, through depositions and settlements and client meetings and firm lunches and bar association events and everything else that constitutes the texture of a working attorney's life, Alex Murdaugh was simultaneously playing a role and systematically dismantling the financial interest of the people that role obligated him to protect. His clients were not abstractions. They were the kinds of people who come to personal injury and wrongful death attorneys precisely because something terrible has happened to them and they have no other way to seek redress. They were people at the worst junctures of their lives, people who had lost family members, who had been injured, who were navigating the aftermath of accidents and negligence with limited resources and little sophistication about how legal settlements work. They trusted the firm, they trusted the name, and in trusting the name they trusted Alex Murdaugh, who used that trust as the operational prerequisite for the theft. The mechanics of how he did it involved routing settlement funds through accounts that clients were either unaware of or could not easily monitor, then diverting the money before it reached its intended destination. The firm itself was also a victim. PMPED's own money was stolen, its financial records manipulated to conceal the withdrawals. The precision required to sustain this over 11 years, to keep the numbers from surfacing in audits, to manage the timing of diversions against the rhythm of the firm's normal financial operations, speaks to a level of deliberate, calculated effort that makes the duration harder, not easier, to comprehend. This was not someone who stole once and got lucky. This was someone who stole repeatedly, in multiple variations across multiple cases, and constructed enough procedural camouflage to keep it hidden for over a decade. But the machinery was never entirely frictionless. There were clients who asked questions. There were moments when explanations had to be produced and timelines adjusted and documentation manufactured or withheld. Each of these moments was a near miss. Each one required Alex Murdaugh to draw on exactly the currency the Dynasty had provided him: credibility, the presumption of integrity, the institutional weight of the name. When a man with his family background and his professional standing told a client that a settlement was still being processed, that paperwork was pending, that the numbers would resolve in time, the name itself was the reassurance. The Dynasty was the mechanism that made the fraud survivable, year after year, near miss after near miss. And then there was Gloria Satterfield. Satterfield had worked as a housekeeper for the Murdaugh family for years, a trusted presence in their domestic life, someone whose relationship with the family predated any of the financial crimes and existed in an entirely different register. She knew the household, she knew the children. On February 26, 2018, she died at the Murdaugh home after what was reported as a trip and fall accident on the property. She was a family employee in a family home, and the circumstances of her death were initially treated as a tragic accident, the kind of misfortune that can befall anyone in the course of ordinary domestic life. But the aftermath of Satterfield's death is where the story becomes something different. Alex Murdaugh arranged a wrongful death settlement with Satterfield's estate. On the surface, this was a conventional legal outcome. A death occurred on the property, the family acknowledged liability, a settlement was reached. The amount was $500,000, not an unusual figure for a wrongful death claim of this type. What Satterfield's sons received from that settlement is a separate and more disturbing question, because prosecutors later alleged that Alex Murdaugh stole approximately $4.3 million from her estate. Not from the settlement itself, from the broader estate management process, through a scheme that required a co-conspirator. That co-conspirator was Corey Fleming, an attorney and close friend of Alex Murdaugh's. The allegations describe a structure in which the settlement funds were directed in ways that enriched both men at the expense of the Satterfield estate, and ultimately of the two sons Gloria Satterfield left behind. And a $4.3 million is an extraordinary sum relative to a $500,000 settlement. The gap between those two numbers is itself a measure of how far the scheme extended beyond the original transaction. The Satterfield sons did not know, according to the public record, the full details of what had been done with their mother's estate, until the wider financial investigation of Alex Murdaugh was already underway years later. There is an aspect of the Satterfield theft that sets it apart from the other financial crimes in the case, and it is not just the dollar amount, it is the relationship. Gloria Satterfield worked inside the Murdaugh home. She knew Alex Murdaugh not as a client or an opposing party or a professional contact. She knew him as her employer, as someone whose children she'd been around, as a presence in the intimate geography of domestic life. The theft from her estate was not impersonal. It required Alex Murdaugh to see the death of a woman who had worked in his home, and to register it, at some operative level, as an opportunity. That is a different kind of calculation than routing a settlement through a misdirected account. It requires a compartmentalization of relationship and intention so complete that it is difficult to describe without sounding like hyperbole. And yet the financial record, as documented in the subsequent charges and proceedings, supports that it happened. By the time Gloria Satterfield's estate had been handled, and the money had moved to where Alex Murdaugh and Corey Fleming had directed it, the financial scheme had acquired a new dimension. It was no longer solely a matter of diverting settlement funds from strangers who had no daily window into his life. It had extended to someone inside the household, which meant it had extended to the most intimate perimeter of the Murdaugh world. Less than a year later, the perimeter contracted further. On February 24th, 2019, at 2:17 in the morning, Paul Murdaugh crashed the family's boat into the Archers Creek Bridge in Beaufort, South Carolina. Paul was 22 years old. Witnesses and subsequent investigation indicated he had been drinking. Among the passengers aboard the boat was 19-year-old Mallory Beach. The crash killed her. Mallory Beach's death was not an abstraction in the Low Country. She was a young woman from the community, connected to the social network that runs through small South Carolina counties, the way rivers run through the landscape, everywhere, touching everything. Her death generated the kind of grief and anger that does not stay quiet, and her family pursued legal action that carried with it not just financial consequences but reputational ones. The civil litigation arising from the boat crash became a documented threat to the Murdaugh family on multiple fronts simultaneously. The financial exposure was real, but so was the discovery process, which in civil litigation can require the production of documents and testimony about financial arrangements that would otherwise remain invisible. If this is the connective tissue that prosecutors would later argue ran from the boat crash to the murders, the civil case against Paul, and by extension against Alex as his father and as the person whose household resources and professional network were entangled in the matter, created a legal mechanism through which the financial crimes might surface. Discovery is a powerful tool. Plaintiffs' attorneys in civil proceedings can subpoena records, compel depositions, request documentation of financial accounts and transfers. The Murdaugh financial architecture, constructed over 11 years to remain below the threshold of official notice, was now potentially visible to parties with both the legal standing and the motivation to look at it carefully. Alex Murdaugh was the attorney of record in his own family's legal affairs. He was also a man whose financial records, if examined closely, would reveal not one or two irregular transactions, but a decade-long pattern of diversions and thefts totaling nearly $10 million. The civil litigation over Mallory Beach's death was, from that perspective, not just a source of financial pressure, it was a potential opening through which the entire concealed architecture of his professional life could become exposed. The pressure compound here is important to register. The Satterfield matter had introduced one vector of exposure. The Beach litigation introduced another, operating through a different legal mechanism, with different attorneys at a different pace. These were not the same threat coming from the same direction. They were converging lines of scrutiny, each with its own timeline and its own capacity to generate documentation that Alex Murdaugh could not entirely control. A man managing the collapse of one financial scheme can sometimes do it. A man managing two simultaneous collapse vectors in different legal proceedings, while continuing to steal in order to fund the lifestyle and the addiction the theft had been financing, that man is running a race he cannot win. Because the theft did not stop, even as the Satterfield matter was in motion, even as the Beach litigation was developing, even as the financial pressures of maintaining the concealment were intensifying, Alex Murdaugh continued to divert funds. The opioid addiction that he would later describe from the stand as a cause of his paranoid and irrational thinking was by this period consuming enormous resources. The theft, which had perhaps begun as a way to supplement income or cover specific gaps, had by the early 2020s become entangled with the financial demands of a serious drug dependency. The two were feeding each other. The addiction created financial need. The theft provided the resources. The escalating risk of exposure generated paranoia and stress, and the drug use was, at least in part, a response to that stress. Each element of the cycle was making the others worse. By early 2021, Alex Murdaugh's ability to keep the plate spinning was measurably deteriorating. The financial records that would eventually be presented at trial showed that the pace and scale of the theft had intensified in the final period. The civil litigation was producing discovery demands. The PMPED partnership was not a passive entity. It had financial controls, reconciliation processes, oversight structures that any sufficiently anomalous pattern of disbursements would eventually strain. 11 years is a long time to stay below the threshold of notice, and the threshold was moving closer. June 7th, 2021 arrived as an ordinary Monday. It would not remain that. At some point during that day, and the specific timing matters enormously in light of what followed that evening, the chief financial officer of PMPED confronted Alex Murdaugh about $792,000 in missing funds. Not a rumour, not concern. A direct documented confrontation about a specific sum that could not be accounted for, and that the firm's financial records connected to Alex's conduct. $792,000. This was not the full scope of what Alex had stolen, not even close, but it was enough to be a threshold moment. The CFO was not a colleague asking a gentle question. This was the firm's financial officer, sitting across from a partner, presenting numbers that could not be explained away. The 11-year architecture of concealment had produced this moment, a confrontation inside the firm with someone who had both the professional authority and the documented evidence to make the accusation stick. What Alex Murdaugh did after that confrontation for the remaining hours of June 7th, 2021, is a matter of the public record in the most consequential possible sense. But what that confrontation represented, the thing it had definitively closed, was the possibility of more time. There would be no more management of timelines, and no more routing of explanations, no more drawing on the institutional credibility of the dynasty to absorb a question and release it harmlessly. The exposure that had been building since 2010 that had narrowed through the Satterfield matter and the Beach litigation and the gathering discovery demands, had arrived at a specific room on a specific day with a specific number attached to it. The 11 years were over. The $792,000 was the beginning of the end of everything, and Alex Murdaugh knew it by the time he left that meeting. What the prosecution would later argue is that the man who drove to the Moselle property that evening had already been confronted with the irreversible knowledge that the financial crimes were no longer containable. The $8.5 to $10 million of the Satterfield theft, the Fleming arrangement, the Beach litigation, the addiction, all of it was converging. The machine that had run on the Dynasty's credibility and the firm's trust for over a decade had finally seized. That evening at approximately 8:44 p.m, Paul Murdaugh took out his phone and started recording a video at the dog kennels. The date stamp on that video, and what it captured, and what it would later prove in a courtroom, none of that was in anyone's mind at the moment it was recorded. It was just a young man at the kennels on his family's land on a summer evening, pointing his phone at a sick dog. 53 seconds, the last documentation of 3 people in the same place, alive. 53 seconds of video recorded at 8:44 in the evening on a piece of land so large it has its own internal geography. The Moselle property sits in Islandton in Colleton County, South Carolina. 1,770 acres of hunting land, woodland and open ground that the Murdaugh family had held for generations. It is the kind of property that takes time to cross. The kennels where Paul Murdaugh pointed his phone that evening were one feature among many on grounds that included multiple outbuildings, a main residence, roads between structures, and the accumulated infrastructure of a working hunting estate. This is not a backyard, it is a landscape. And on the night of June 7th, 2021, the distances between the structures on that landscape would become, in a courtroom 18 months later, a precise and devastating argument. Paul was 22, Maggie was 52. They had both been at the kennels. That much is established by the video and by what the video captured, which is the ambient texture of an ordinary summer evening in the Low Country. The sound of dogs, the particular quality of low light in the humidity of a South Carolina June, and voices. The video is brief enough that you can almost forget what it contains. A sick dog was the apparent focus. One of the family dogs had something wrong with it, and Paul was documenting the animal for reasons that had nothing to do with the events that followed. But the camera pointed at the dog captured what surrounded it. Maggie's voice. Paul's voice. And as Alex Murdaugh approached the kennels, Alex's voice, calling for the family's yellow Labrador, a dog named Bubba. Paul said, in the easy, unremarkable way a young man greets his father, "Hey, Dad," Maggie called out for Eddie, the caretaker Eddie Smith, in the background. These were the sounds of people who were nowhere near the end of anything they could perceive. That video timestamp, 8:44 p.m, became the foundation of the prosecution's entire chronological architecture. Not because it proved what happened next, because it proved where Alex Murdaugh was, and when, and in the company of whom. He would later tell investigators he had not been at the kennels that evening. He would say he had been inside the main house, that Maggie and Paul had gone to the kennels without him, that he had been napping before leaving the property to visit his mother. He maintained this account in the initial days and weeks following the murders, and it was the account that the 53-second video destroyed completely. His voice was on the recording, not a voice that sounded like him, not a voice that could have been someone else. His voice, identified at trial by multiple witnesses who knew him, and confirmed by at least one juror who, hearing it for the first time in the courtroom, recognized it with the specific clarity that attaches to a recognition you are not expecting. "I don't know him," that juror said afterward, "so I never knew his voice, but I realized it was him in the kennel video, and that just kind of sealed the deal." Sealed the deal, a quiet phrase for an enormous fact. Now hold the timeline at 8:44 p.m, 3 people at the kennels, Alex's voice on the recording, the evening doing what summer evenings do in South Carolina, cooling, slowly, toward dark. At 10:07 p.m, Alex Murdaugh called 911. That is an 83-minute window. 83 minutes between the last documented moment of all three people alive in the same location and the moment Alex Murdaugh told a dispatcher he'd arrived home and found his wife and son shot to death. 83 minutes inside which everything that matters in this case either happened or needs to be accounted for, and that accounting is precisely what the prosecution spent the better part of a 28-day trial constructing. The 911 call itself is a document. Alex told the dispatcher that he had come home, that he had found Maggie and Paul, that they had been shot. His effect on that call, the specific quality of his voice, the words he chose, the pace of his delivery, I suppose, was examined in the trial and scrutinised extensively in the broader public discussion of the case. Yet these are matters on which reasonable people have drawn different conclusions, and it would be dishonest to present the 911 call as straightforward evidence of guilt on its own terms. What it is, unambiguously, is the fixed point at which the evening became an official investigation. Deputies and first responders arrived at the Moselle property in the minutes that followed. And what they found, and what their body cam footage recorded, was a scene whose geography told its own story. Paul was found near the dog kennels. He was 22 years old and he had been killed with a shotgun at close range. The specifics of a shotgun wound at close range do not need to be elaborated upon at length. What matters is the weapon type, because Maggie was not killed with a shotgun. Maggie Murdaugh was found approximately 30 yards from the kennels. 30 yards is not a great distance on a property this size. She was not far from where Paul's body was found, but she was not in the same spot. The distance between them was 30 yards, and the weapon that killed her was an assault rifle. Two different firearms, the same location, broadly understood, but two different weapons, two different victims, separated by 30 yards and by the particular facts of their respective wounds. The body cam footage from that night captured the property in the way only actual documentation can, not as a described crime scene but as a place, with specific ground underfoot and specific structures visible and specific distances between things that a jury would later walk themselves. The footage showed the kennels. It showed the path between where Paul was found and where Maggie was found. It showed the outbuildings and the approach roads and the main house and the entire spatial relationship of the elements that would become, in the months ahead, the subject of forensic analysis and courtroom argument. There is something particular about body cam footage from the immediate aftermath of a crime. It has not yet been shaped by narrative. The camera does not know what it is looking at in terms of evidence. It is simply recording a place where something has happened, in the order in which the person wearing the camera encounters that place. The result is a kind of accidental documentary authenticity that neither prosecution nor defense fully controls. What the footage from that night documented was the geography of violence. Two people, two weapons, thus one piece of land, one family. The prosecution's timeline argument was built on a simple but powerful structure. At 8:44 p.m, the kennel video places Alex, Maggie and Paul together at the kennels. At 10:07 p.m, Alex calls 911 to report the deaths of Maggie and Paul at those same kennels. The prosecution's position was that within that 83-minute window, Alex Murdaugh killed his son with a shotgun and his wife with an assault rifle, then departed the property, then returned and made the 911 call from the position of a man who had just discovered the bodies. The narrative architecture of an innocent discoverer, the shock, the arrival, the finding, was, in the prosecution's framing, a performance staged after the fact. This framing depended on the jury accepting that the kennel video voice was Alex's, and that Alex's initial denial of being at the kennels was therefore a deliberate lie rather than a misrecollection or confusion. The jury did accept this. They had 83 minutes as a container. They had two weapons. They had the 30-yard distance between the bodies. They had the timeline, confronted that morning about missing hundreds of thousands of dollars, at the kennels with his family by 8:44 p.m, calling 911 at 10:07 p.m. and they had the fact that Alex Murdaugh had lied about being there at all until the video made the lie untenable. The defence introduced the possibility of two shooters, a framework in which someone else, or more than one other person, had come onto the Murdaugh property that evening and committed the murders while Alex was absent. The boat crash litigation had generated enemies. Paul Murdaugh had provoked real anger in the community over Mallory Beach's death. There were people, the defence argued, with motive to target Paul specifically. The two-weapon finding was, in this interpretation, consistent with two assailants, rather than one person switching between firearms. This theory did not survive the jury's deliberation. 45 minutes of deliberation, after 28 days of trial, is a number that contains its own implicit verdict on the persuasiveness of the two-shooter argument. The jury was not divided. They were not prolonging the deliberation to resolve competing interpretations of the physical evidence. Whatever questions remained about the specific forensic details of the shooting sequence, the jury reached its conclusion in a time frame that suggested the evidence, taken as a whole, and left them with very little genuine uncertainty. But the physical questions are worth sitting with, because they are not trivial. The prosecution argued that Alex acted alone, moving between Paul and Maggie using two different weapons. The 30-yard distance between the bodies introduces a spatial element that the jury presumably was asked to account for. If Paul was killed first, near the kennels, the question of how Maggie came to be 30 yards away, whether she fled, whether she was moved, whether the sequence of the killings has a particular order, is a question the prosecution addressed and the defence contested. The ballistics, the positioning, the wound patterns, these were presented, examined, cross-examined, and ultimately weighed by 12 people in a room in Colleton County. The jury visited the Murdaugh property during the trial. They walked the grounds, they stood at the kennels, they stood at the approximate location where Maggie's body had been found, 30 yards away, and they looked at the distance between those 2 points with their own eyes, in person, on the actual land. There is no substitute for this kind of evidence encounter. A photograph, a diagram, a testimony, all of these render the geography into representation. The jury walked the actual distance. They experienced the specific relationship between the kennels and the point 30 yards out where Maggie Murdaugh died. This is a significant thing to do in a murder trial, and it is not routinely done. The Murdaugh visit was a decision as by the judge, agreed to by both sides, that the physical reality of the crime scene was material to the jury's understanding of what was alleged to have happened. And physical reality, experienced directly, has a weight that no amount of courtroom presentation can entirely replicate. The jurors who walked that land in Colleton County were standing in the same space where Paul had pointed his phone at a sick dog at 8:44 on a June evening, and where the bodies of 2 people had been found an hour and 23 minutes later. The land itself was evidence. The distances were evidence. The 53-second video was evidence. The 911 call was evidence. And the accumulation of these things, the timestamp, the voices, the geography, the lies, the morning confrontation about missing funds, was the architecture the prosecution had spent months constructing and 28 trial days presenting. Here is what is known and documented. Paul Murdaugh and Maggie Murdaugh were alive at the kennels at 8:44 p.m. on June 7, 2021. Alex Murdaugh was with them. By 10:07 p.m. both were dead, killed with 2 different firearms at 2 locations 30 yards apart. Alex Murdaugh placed the 911 call. He told the dispatcher he had found them. Here is what became the hinge of the entire prosecution. He had told investigators he wasn't there that evening. He had said it more than once. He had constructed in the hours and days following the murders an account of his movements that specifically excluded him from the kennels at 8:44 p.m, and then a 53-second Snapchat video surfaced. This with a timestamp, with his voice on it, saying nothing incriminating, just calling for a dog named Bubba, the most ordinary possible syllables, and the account he had constructed collapsed entirely. The lie about being at the kennels was not by itself proof of murder. Innocent people lie to investigators for complicated reasons. The defense acknowledged Alex lied. Alex himself eventually acknowledged it. The question the prosecution pressed was a different one. Why would a grieving father, who had just lost his wife and his son, lie specifically about being at the location where they were killed in the last minutes before they died? What does that lie protect, and what does it reveal about the state of knowledge of the person who told it? The jury took 45 minutes to answer that question. They did not need the lunch hour. What remained after the verdict, what the body cam footage captured and the property visit confirmed and the timeline established, was the specific shape of a specific night. A summer evening on a low-country hunting estate, dogs at the kennels, a young man with his phone, a woman calling out for a caretaker, a man calling for his dog. And then 83 minutes that the evidence could not adequately explain away. 83 minutes that a jury decided required only 45 of their own to resolve. The property still stands in Islington, in Colleton County. The kennels are still there. The 30 yards between where Paul was found and where Maggie was found is still 30 yards. A piece of land holds its distances even when everything else has changed, so it takes a particular kind of confidence, or a particular kind of desperation, to put yourself on the stand in a double murder trial. Defense attorneys debate the decision in every serious criminal case, and the calculus is almost always the same. The risks of cross-examination, the opportunity to humanize, the danger of giving the prosecution a live body to destroy in front of the jury. Most defendants in cases with this weight of evidence do not testify. Alex Murdaugh testified. The decision to take the stand was, depending on how you read it, either his attorney's best remaining move or an act of profound miscalculation. The state had built its case on documents, timestamps, a video, and a lie. The defense needed something the evidence could not provide. A human being sitting in a wooden chair and explaining himself. What the jury got over the hours of direct and cross-examination that followed was an explanation that explained very little and an admission that cost everything. Alex Murdaugh is a large man, physically imposing in the way that men from his background and generation sometimes are, the product of a certain kind of southern upbringing, a certain kind of athletic youth, a certain kind of professional life spent in courtrooms where bearing matters. He took the stand in a suit, and he looked like what he was, a lawyer who had tried cases in rooms like this one for 3 decades. He knew the choreography of testimony. He understood the structure of examination and cross-examination from the other side, and he used all of that knowledge, and it was not enough. On direct examination, he presented himself as a man destroyed by grief and addicted to opioids, a combination intended to explain his irrational behaviour in the aftermath of the murders, including the lies he had told to investigators. He confirmed the basic narrative his defence was offering, that he was not at the kennels that evening, that he had been elsewhere on the property, that he was as devastated as anyone who has lost a wife and a child could be. He spoke about Maggie. He spoke about Paul. He did what defendants on the stand are coached to do, which is to make the jury see a human being rather than an indictment. And then he admitted he had lied. Not in the hedged, lawyerly way that some defendants admit to prior inconsistencies, the "I may have been mistaken," that my recollection at the time was imperfect. He admitted it plainly, and in admitting it, reached for language that was either a genuine literary reflex or the most self-defeating rhetorical choice in the history of South Carolina criminal trials. "Oh, what a tangled web we weave," he said on the stand. "I meant when I lied, I continued to lie." He was quoting Sir Walter Scott. The line is from Marmion, a narrative poem published in 1808, and its context in the original is a meditation on deception and its consequences. Whether Alex Murdaugh reached for it because it was genuinely the phrase that came to mind, or because the literary flourish felt like it might lend some weight or self-awareness to the admission, is impossible to know with certainty. What is documentable is what it sounded like in a murder courtroom in Colleton County. A man acknowledging, in his own words, not just that he lied, but that once he began lying, he could not stop. A tangled web. Continued lies. He had handed the prosecution a confession in iambic cadence that it would not let go of for the rest of the trial. His explanation for the lies centered on opioid addiction. He described a dependency that had grown severe enough to distort his judgment, to produce paranoia, to cause him to say things to investigators that he knew, on some level, were false, but that his addicted and panicked mind had generated anyway. The opioid explanation was not invented for the courtroom. His addiction was documented and acknowledged by multiple people in his life, and it is a genuine fact of the case that Alex Murdaugh had a serious drug problem. But the prosecution's response to this explanation was direct and unsparing. Addiction might explain impulsive behaviour, might explain financial crimes committed to fund a habit, might explain erratic decision-making across a range of contexts. It did not, the prosecution argued, explain a specific lie about a specific location at a specific time that happened to be the location where his wife and son were murdered within the hour. The distinction matters. Alex Murdaugh's explanation placed his lies in a category of generalized irrational behavior, the paranoia and fear and chemical fog of a man who was not thinking clearly. The prosecution placed those same lies in a different category entirely. Deliberate, targeted, self-protective falsehoods told by someone who knew exactly what had happened at the kennels that evening and understood exactly why he needed distance from it. The jury was asked to determine which of these two framings was more consistent with the evidence as a whole. They took 45 minutes. There is something genuinely difficult about watching a person dismantle themselves on cross-examination, even a person who may have committed terrible things. The prosecution moved through the inconsistencies in his testimony with the methodical precision of lawyers who have had weeks to prepare for this specific witness, and Alex Murdaugh, who had practiced law for 30 years, who understood the structure of cross-examination intimately, could not navigate it. He was asked about specific statements he had made. He was asked about specific timelines that his testimony did not fit. He was asked, again and again, to account for the gap between what he had said and what the evidence showed. And again the accounting fell short. The Scott quote lived in the room. It did not leave. When a man quotes a poem about deception while admitting to sustained deception, in a murder trial, the quote becomes a headline, and then it becomes a shorthand, and then it becomes, in the minds of the people deciding his fate, a kind of self-portrait that he painted himself. I continue to lie. He said it. The prosecution did not have to characterize him. He had characterized himself. There were other voices in that courtroom, and they matter. Blanca Terubiat Simpson had worked in the Murdaugh home for years as a housekeeper. She knew the family with the particular intimacy that domestic employment creates. She had been present for ordinary mornings, ordinary disputes, the texture of a household in its unguarded moments. She knew Maggie. She testified about that knowledge with emotion that was not performed, and her grief over Maggie Murdaugh was a specific, rooted grief. The grief of a person who had actually known the woman being mourned rather than encountered her only through evidence and photographs and forensic reports. Her testimony about Alex was something different. She had trusted him, she said, in the absolute way that years of proximity and no visible reason for suspicion can build. There was no universe, she told the courtroom, in which Alex could have committed these crimes. It is a remarkable phrase. Totalizing without exception, no universe in which the thing was possible. And she had believed it. She'd believed it until the evidence accumulated to a point where the belief was no longer sustainable, and when it collapsed. The collapse was not abstract, it was personal. It was the specific ruin of a specific confidence built over years of actual relationship. She also said, separately, I refuse to be intimidated, a statement about the pressures she had faced for speaking out, pressures that speak to the broader dynamic the Murdaugh name still exerted in certain quarters, even after the arrest. These are two separate declarations from the same witness. One about what she believed before the evidence, and one about the resistance she encountered when she chose to honour what the evidence required. Both are worth holding. Buster Murdaugh was 26 when his father stood trial for killing his mother and his brother. He testified, and the position he occupied in that courtroom is one of the genuinely heartbreaking facts of this case. Not because Alex Murdaugh deserves sympathy, but because Buster did not choose any of it. He had lost Paul. He had lost Maggie. And the man on trial for those losses was his father. He testified that his father was broken after the murders, that the Alex Murdaugh he saw in the days that followed was a man undone, hollow, the opposite of someone who had committed violence and was managing the management of it. This is the defence's best evidence in human form. Not documents or timelines or forensic arguments, but a surviving son describing a broken parent. The prosecution could not take that away from Buster, and it did not try. What the prosecution could do, and did, was situate that testimony within everything else. The lie about the kennels, the financial confrontation that morning, the opioid admission, the Scott quote, and ask the jury to weigh the description of a broken man against the evidence of what that man's behaviour before and during the investigation actually looked like. Grief and guilt can produce similar visible symptoms. The jury was left to determine which one they were seeing. Buster Murdaugh occupies a position that has no clean category. He is the surviving victim. He is also the only surviving immediate family member of the man convicted of the crimes that made him a victim. His public existence since the verdict has been its own kind of prolonged and unresolvable loss, and no verdict changes the specific geometry of what he has had to carry. He did not testify against his father. He testified for him. He testified about a broken man. The jury found that man guilty anyway, in 45 minutes, and the specific weight of that finding on the person who described his father as broken is not something the trial record can fully contain. John Marvin Murdaugh is Alex's brother. His testimony illuminated the morning after the murders with the specific, unstaged quality of someone describing an experience before it had fully resolved into meaning. He said that the day after the killings, before the investigation had developed, before the full picture of what had happened at Moselle was taking shape in the public record, he wanted to go to the dog kennels, not for evidentiary reasons, not because he suspected anything, because the kennels were where it had happened, and sometimes the impulse of grief is to go to the place rather than away from it, yet to be in the physical location as though proximity to the site offers some access to understanding that distance forecloses. John Marvin Murdaugh, going to the dog kennels the day after his brother's wife and nephew were killed, there is a detail that belongs in the category of raw human response. Not evidence of anything except the way people move through catastrophe before they know it is catastrophe. What his testimony also did, perhaps without intending to, was restore the kennels to their ordinary function in the life of the family before the case had reduced them entirely to evidentiary geography. The family had relationships with that place. People cried for the people who had died there. And John Marvin's instinct to go to the kennels was the instinct of someone whose grief was still attached to the person, rather than to the legal significance of the location. At sentencing, after the verdict, after the 45 minutes, after everything, Alex Murdaugh spoke to his son. To Buster, he said, "I am so very sorry." A sentence that short, carrying that much, can be read in at least two ways. It can be the apology of a guilty man to the only child he did not destroy, or it can be the apology of a man who, even if he did not commit the murders, has undone Buster's life through the financial crimes and the lies, and the trial and the conviction, and the 2 consecutive life sentences. Either reading contains genuine damage. Either reading is addressed to a person who has lost both parents and a brother, and is now receiving an apology from a man the state of South Carolina has found guilty of causing 2 of those losses. I am so very sorry. It is an incomplete sentence in every direction. Sorry for what, precisely? Sorry for the murders, if he committed them. Sorry for the lies, which he admitted. Sorry for the financial crimes, which he also eventually admitted to in separate proceedings. Sorry for the opioids, which he offered as partial explanation for all of the above. The apology does not specify, and that absence of specificity is itself a kind of document. A man who was innocent of the murders and sorry only for the lies he told in their aftermath might be expected to say that, to draw the distinction clearly, done to make sure his surviving son understood what the apology covered and what it did not. Alex Murdaugh did not draw that distinction. He said he was sorry. He said Buster's name. He stopped there. The courtroom in Colleton County saw many things over 28 days. It saw a man quote Sir Walter Scott while admitting to sustained deception. It saw a housekeeper who had believed in the impossibility of Alex's guilt arrive at a different conclusion through the accumulation of evidence. It saw a surviving son describe a broken father. It saw a brother move through the early hours of grief with the honest, unstaged impulse to go to the place where it happened. And it saw a jury return after 45 minutes, with a verdict that resolved the question of legal guilt, while leaving the deeper questions about what a man tells himself, about what a family absorbs, about what the people left behind carry, permanently open. Alex Murdaugh on the stand was a lawyer who knew what a cross-examination looked like from the inside and who could not survive it. He was a man who, having told the jury he had lied repeatedly, then tried to explain the lies in terms that the jury found insufficient. He was a defendant who reached for literary language at the precise moment that plain language would have served him better, or would have served no one at all. He was in the final accounting a man sitting in a chair answering questions about 83 minutes that the evidence had already largely answered. The tangled web was his phrase. He chose it. And the jury in 45 minutes decided they understood what it meant. The verdict and the sentencing gave the Murdaugh case the shape of resolution. 2 consecutive life sentences, the financial guilty pleas to follow, the federal charges on top of those. A man was convicted, a family's private catastrophe became public record, and the legal system, after bending considerably, produced an outcome. But there is a particular quality of unease that attaches to cases like this one, an unease that does not dissolve when the jury comes back, because the jury was only asked about certain things. There are deaths in the orbit of the Murdaugh family that no jury has ever formally addressed. There are questions that were never properly posed, in the years when posing them might have mattered most, and the answers, if answers exist, remain somewhere outside the frame of what has been officially resolved. And Stephen Smith was 21 years old when his body was found on Sandy Run Road in Hampton County, South Carolina, in the early hours of July 8th, 2015. He was lying in the middle of the road. The official determination was a hit and run. A vehicle had struck him, the driver had not stopped, and that was what the initial investigation concluded. Hampton County is small, rural, the kind of place where everybody knows which family owns what and which name carries weight in which room. Stephen Smith had grown up there. He was not from the world of the Murdaughs. He had no obvious connection to the legal dynasty that had run the 14th Judicial Circuit for generations. And yet, in the early stages of the investigation into his death, witnesses began to mention a name, not just in passing. The name came up from multiple witnesses. Multiple times. The name was Murdaugh. Law enforcement at the time did not publicly explain why the name surfaced or what was done with that information. The investigation was closed with the hit-and-run ruling, and Stephen Smith's death entered that particular category of outcome that looks like resolution from a distance, but begins to look different the closer you get. His mother, Sandy Smith, never accepted the conclusion. She pursued it in the years that followed, raising questions about the physical evidence, about what the scene actually showed, about whether the injuries to her son were consistent with what a vehicle strike in a rural road collision produces. Forensic experts who examined the case independently raised the same questions. The pattern of injuries, the positioning, the absence of typical debris. These were not settled facts pointing cleanly toward the official finding. Then the Murdaugh investigation began. In the summer of 2021, as law enforcement and prosecutors started examining the constellation of deaths and crimes surrounding Alex Murdaugh, the South Carolina Law Enforcement Division announced that the investigation into Stephen Smith's death had been officially reopened as a homicide. The word matters, not an accident, not an unresolved accident, a homicide. The official characterization of what happened on Sandy Run Road on July 8th, 2015 changed, 6 years after the fact, triggered not by new forensic discovery in isolation, but by a widening investigation into a different family's conduct entirely. The mechanism that finally reopened the case was the Murdaugh scrutiny, and that sequence, the death ruled as accident, the years of a grieving mother's insistence, the reopening catalyzed by an unrelated investigation, is itself a document about how these things work. The reported offer to pay for Stephen Smith's funeral has never been fully explained. That the Murdaugh family reportedly offered to cover the funeral costs for a 21-year-old from a modest background who had no obvious documented connection to them is a fact that sits in the record without a clean accounting. People offer to pay for funerals for many reasons: generosity, community standing, a sense of obligation, social expectation. But in the context of a death that investigators would later characterize as a homicide, in a community where the Murdaugh name carried institutional weight, the reported offer has a different texture. It is not evidence of wrongdoing. It has not been presented as such, but it is the kind of detail that in retrospect demands an explanation that has not been publicly provided. The question of Buster Murdaugh's relationship with Stephen Smith is one of the most carefully noted unresolved elements of this entire story. Multiple accounts and reports have described an alleged relationship between the two, accounts that circulated in Hampton County before the Murdaugh case became national news, accounts that surfaced again when the case was reopened. Sandy Smith spoke about this publicly. Other community members have described what they understood the connection to be. What has not happened, as of the public record available, is any official, legally established determination about whether that alleged relationship existed, what its nature was, or whether it has any bearing on what happened to Stephen Smith. It would be a distortion to state it as fact. It would be an equal distortion to pretend it has not been raised, repeatedly, by people with direct knowledge of the community. Buster Murdaugh is already carrying the weight of a trial that found his father guilty of murdering his mother and his brother. To layer onto that the unresolved question of a separate death, a reopened homicide investigation, an alleged relationship, without any official resolution, is to describe not a conclusion but a continuing condition of uncertainty. He has not been charged with anything in connection with Stephen Smith. The investigation remains open. What is documentable is that his name has appeared in this context, and that it has never been fully addressed in any official proceeding. The absence of resolution is not the same as the absence of wrongdoing, and it is not the same as the presence of it. It is precisely an absence, and absences in this case have a way of being as consequential as the established facts. There is a version of the Stephen Smith story that has nothing to do with the Murdaughs beyond proximity and the social geography of a small county, and there is a version in which the institutional weight of a family that dominated the local legal system for a century created conditions under which a young man's death was inadequately examined, inadequately pursued, and resolved into an official finding that the evidence may not have actually supported. The investigation is open. The answer is not known. What is known is that it took until 2021, 6 years, and a sprawling separate investigation into an entirely different set of crimes, for anyone with official authority to formally say, this was a homicide, and it needs to be treated as one. Sandy Smith spent those 6 years without that. She spent them with a hit-and-run ruling and the specific grief of a mother who believed her son had been killed and could not get anyone with institutional power to formally agree with her. The reopening of the investigation did not produce an arrest. It did not produce a suspect charged. It produced a reclassification. Sandy Smith's question, who killed her son and why, remains, as of the available public record, unanswered. Gloria Satterfield had worked for the Murdaugh family for years. She cleaned their homes. She was, by multiple accounts, a trusted presence in the household, a person who occupied the particular position that long-time domestic employees occupy in certain families, which is something beyond professional and short of familial, but carrying elements of both. On February 26, 2018, she died following a fall at the Murdaugh home. The official ruling was accidental, a trip and fall, the kind of domestic accident that occurs in homes across the country without raising questions. She was buried. Her family mourned. Life moved on. Alex Murdaugh reached out to her sons after her death. He expressed sympathy. He suggested they pursue a wrongful death claim. He recommended a lawyer. The lawyer he recommended was Corey Fleming, who had been his close friend since their time together at the University of South Carolina. Fleming would later plead guilty to his own role in the financial scheme, would stand before a judge and say that he deserved to be punished, that he had no excuses, that he took full responsibility. But in 2018, when Alex Murdaugh recommended Fleming to the Satterfield family, he was presenting himself as a concerned employer, a man of legal expertise, someone who could help the family of a woman who had died in his home navigate a complicated process. The settlement the Satterfield estate received was $500,000. That is the number that was communicated to the family. What the family did not know, what they were not told, was that the insurance companies had paid out substantially more than that. Approximately $4.3 million, according to the allegations against Alex Murdaugh. They flowed through accounts in the Satterfield matter that her sons never saw. The money moved, as so much of Alex Murdaugh's stolen money moved, through structures that were designed to obscure rather than illuminate. Gloria Satterfield's sons received a fraction of what her death had actually generated. The rest disappeared into the same pattern of theft that characterized a decade of Alex Murdaugh's financial life. But here is the question that precedes all of that, the question that sits underneath the theft and the settlement and the fraudulent accounting. Why was Gloria Satterfield's death never investigated as a potential homicide? Not charged as one, not determined to be one, asked about as one. She died in the home of a man who, it would later emerge, he had a documented pattern of using the deaths of people around him as financial instruments. She died at a time when Alex Murdaugh was already, according to the eventual evidence, engaged in significant financial theft. Her death was ruled accidental. No investigation into its circumstances appears to have been conducted with any serious scrutiny. She was the housekeeper. He was the Murdaugh. The dynamic between those two facts in Hampton County, South Carolina, may have been its own sufficient explanation for why no one looked harder. The accident determination was never formally challenged during her lifetime. She was not alive to challenge it, and was not revisited in the years following her death, even as Alex Murdaugh began stealing from her estate. The theft itself was discovered only after Alex Murdaugh's financial crimes were being examined in the context of the murder investigation. If Maggie and Paul Murdaugh had not been killed on June 7th, 2021, it is an open question whether Gloria Satterfield's family would ever have learned that the settlement payment they received bore no relationship to what the insurance companies had actually paid. It is an open question whether the circumstances of her death would ever have received any additional examination at all. That question is not rhetorical. It is a documented structural reality. The investigation that exposed what had been done to Gloria Satterfield's estate was the same investigation triggered by the murders of Maggie and Paul Murdaugh. The connection is not incidental. It is the mechanism by which the Satterfield family learned the truth of their own situation. What Stephen Smith and Gloria Satterfield share is not a proven perpetrator. They share a context. They both died in circumstances that were resolved quickly, without apparent rigorous scrutiny, in a county where one family had exercised generational influence over the legal and institutional structures responsible for that scrutiny. They both occupied positions of social vulnerability relative to the Murdaugh family. A young man from a modest background with a rumoured connection to the Murdaugh name, a domestic employee in the Murdaugh household. They were both, in a documentable sense, People for whom the ordinary mechanisms of institutional accountability fail to engage with any particular urgency. This is not a conspiracy theory. Conspiracy requires intent and coordination and a specific shared goal. What this is, more accurately, is a systemic failure of the kind that concentrated institutional power reliably produces. When one family has held prosecutorial authority, judicial proximity, and community deference for a century, the result is not always a deliberate cover-up. Sometimes the result is simply that no one asks the harder question, because asking it has never been necessary before, and the social and professional costs of asking it in the wrong direction have always been visible enough to discourage inquiry. The accident gets ruled an accident. The hit and run gets ruled a hit and run. The paperwork is filed, the file is closed, and the family whose name hangs over everything continues to hang over everything. The reopening of the Stephen Smith investigation in 2021 was the system correcting itself, belatedly and partially. But correction implies that something wrong had persisted long enough to require correcting, and that persistence is precisely the point. 6 years, 3 years. The lengths of time during which these deaths sat in their official categories while evidence to the contrary existed, while a grieving mother was insisting, while an estate was being looted, while the man at the centre of everything was still practising law and still attending cases and still being Alex Murdaugh in the county, where being Alex Murdaugh meant something specific and protective. There is a particular kind of harm that comes not from what the powerful do, but from what they prevent others from doing. From the questions that are never asked, the investigations that never opened, the reclassifications that take 6 years to arrive. Gloria Satterfield's sons lost their mother and were then robbed of her legacy. Sandy Smith has spent nearly a decade trying to get an official answer about her son's death. Both families paid the cost of living in the shadow of a name that, it turns out, was extended over things it should never have been allowed to cover. The murder trial answered the question it was asked. It answered whether Alex Murdaugh killed Maggie and Paul. It did not ask, could not ask, within the constraints of that proceeding, whether the culture of deference that had surrounded the Murdaugh family for a century had permitted other harms to go unexamined. That question belongs to a different category of inquiry, one that the criminal justice system is structurally ill-equipped to conduct about itself. The Stephen Smith investigation is open. The circumstances of Gloria Satterfield's death have been examined in financial terms but not officially in any other. The deeper questions, whether these deaths occurred in a context that should have produced more scrutiny, and simply did not because of who lived nearby and what that name historically meant, are questions the public record raises without answering. The listener who finds that unsatisfying is responding correctly. Unresolved is what these cases are. Not because the evidence is necessarily absent, but because for years the mechanism that was supposed to seek evidence was embedded in the same institutional landscape that the Murdaugh family had occupied and shaped for a century. A tangled web, to use a phrase already on the record, not only in a Colleton County courtroom, but in the architecture of oversight and accountability that was supposed to operate independently of the family, whose conduct it was ultimately asked to examine. 2 consecutive life sentences. That is what the jury's 45-minute deliberation produced, or rather, that is what Judge Clifton Newman imposed after it did. The sentence was mandatory under South Carolina law for 2 counts of murder, which meant there was no judicial discretion involved, no weighing of aggravating factors against mitigating ones. The law required it, the conviction triggered it, and Alex Murdaugh would die in prison. That part was settled. The question of whether everything surrounding that outcome was as clean as the sentence itself, that is where the story continued to move, because a verdict is not a fixed object. It exists within a legal structure that allows it to be challenged, examined, and in certain circumstances, overturned. And in the months following Alex Murdaugh's conviction, a specific and serious challenge began to take shape, one that had nothing to do with the evidence presented at trial and everything to do with what allegedly happened inside the jury room. Rebecca Hill had served as the clerk of court for Colleton County. During the Murdaugh murder trial, that position gave her proximity to the jury, administrative proximity, the kind of access that comes with managing the logistical architecture of a proceeding. Her name became central to a post-conviction appeal that alleged she had done something categorically impermissible, that she had communicated with jurors about the substance of the case while the trial was ongoing. Specifically, the allegations were that Hill told jurors not to be fooled by the defence's evidence, that she made comments indicating her own view of Murdaugh's guilt, that she applied pressure, the nature and mechanism of which is itself disputed, in favour of a quick verdict. These are not minor procedural complaints. If a court officer with access to jurors tells those jurors during a trial that the defence is trying to deceive them, that is not a bureaucratic irregularity. That is an interference with the fundamental process by which a jury is supposed to arrive at an independent conclusion from the evidence alone. The American legal system's conception of a fair trial depends on the insulation of the jury from exactly this kind of external influence. It is why jurors are instructed repeatedly about what they can and cannot consider. It is why contact between court personnel and jurors outside the formal record is governed by strict rules. And if those rules were violated in this case, if a court officer with institutional access leaned on the jury in the direction of a conviction, then the 45-minute deliberation that felt like the swiftness of justice may have been, in part, something else. Hill denied the allegations. Her position, publicly stated, was that the claims against her were false. The defence filed a motion for a new trial, and the court was asked to assess the credibility of competing accounts, jurors describing what they remembered, Hill maintaining her denial, and a record that offered no clean, neutral corroboration. What made the allegations particularly difficult to dismiss was their specificity. The claim that she told jurors not to be fooled is precise enough to be testable against individual recollections. The claim that she pressured for speed is precise enough to be assessed against the timeline of deliberations. These were not vague accusations of bias. They were specific behavioural allegations, attributed to a specific person, in a specific institutional role. The motion for a new trial did not succeed at the level at which it was initially argued. But the existence of the claim, the documented allegation, the legal briefing, the formal challenge to the integrity of the proceeding became part of the permanent record of the Murdaugh conviction. It means that the verdict, however swift and however satisfying to those who believed in Alex Murdaugh's guilt, carries with it a documented question about the process that produced it. That is different from the verdict being wrong. It is also different from the verdict being unimpeachable. Then there was the question of the shooters. The defence had argued throughout the trial that the physical evidence at Moselle on the night of June 7, 2021 was consistent with two shooters rather than one. Paul was killed with a shotgun. Maggie was killed with an assault rifle. Two different weapons, two different calibers, two different patterns of injury. And the prosecution's position was that Alex Murdaugh had used both, that he had moved between weapons, that the timeline allowed for it, that the forensic evidence did not require a second person. The defence's position was that the use of two distinct firearms combined with the positioning of the bodies and the trajectory of the shots created reasonable doubt about whether one person had committed both killings. The ballistics and forensic arguments remain genuinely contested in the sense that experts reviewing the same evidence have reached different conclusions about what it requires. That is not the same as saying the jury was wrong to convict. Juries are permitted to credit one expert over another, to find the prosecution's reconstruction more persuasive, to conclude that reasonable doubt was not established. What the two-shooter debate represents is not an exoneration argument, but an acknowledgement that the physical evidence taken alone does not foreclose the possibility of a second person's involvement. The prosecution's case was built substantially on the totality. The kennel video placing Alex at the scene, the financial motive, the timeline, the testimony, rather than on forensic certainty alone. The defence's challenge to that totality was rejected by the jury. Whether it should have been is a question the 45-minute deliberation did not leave much room to explore in depth. The financial sentencing came separately and it came in layers. In November of 2023, Alex Murdaugh pleaded guilty to nearly 24 state financial crimes and received a sentence of 27 years in state prison. The guilty plea was, in its way, a kind of administrative acknowledgement, the formal legal record catching up to what had already been established through the financial investigation. 27 years for the accumulated theft of clients, for the exploitation of vulnerable people in moments of grief and injury, for the operation of a systematic fraud across an 11-year span. Then, in April of 2024, the federal dimension resolved 40 years in federal prison for 22 federal charges that included conspiracy, fraud, and money laundering. That sentence runs concurrently with the state sentences, which means the practical effect on the time Alex Murdaugh will serve is limited by the murder convictions that already ensure he will die incarcerated. But the federal charges are significant not merely as punishment. They represent a separate sovereign, the United States government, formally establishing in its own record that what Alex Murdaugh did met the threshold of federal criminality. That is a legal finding with its own weight, separate from what Colleton County determined. The total exposure between state and federal charges ran to more than 90 counts across the financial crimes alone. The scope of that number is worth sitting with for a moment. 90-plus charges covering theft from clients who had trusted him with their most serious legal matters, personal injury cases, wrongful death claims, the kinds of matters where people come to a lawyer in crisis and place their confidence in the belief that the lawyer will act in their interest. Alex Murdaugh exploited that confidence systematically and repeatedly over more than a decade, across multiple clients, multiple matters, and multiple accounts. Corey Fleming stood before a judge and said what he said. He was specific about the absence of excuse. He was specific about deserving punishment. He had been Alex Murdaugh's close friend since college. He had been the lawyer recommended to the Satterfield family, the conduit through whom at least part of the financial diversion in that matter had moved. His guilty plea and his statement at sentencing represent the only moment in this case where someone directly adjacent to Alex Murdaugh's crimes stood in a courtroom and offered an unqualified acknowledgement of wrongdoing. No defences, no qualifications, no blaming addiction or circumstance. He said he deserved to be punished. He said he had no excuses. He said he took full responsibility. Whether that statement reflects genuine moral reckoning or the strategic posture of a man facing a judge is something the record cannot resolve. What the record shows is that he said it, under oath, in open court, and that the judge who heard it proceeded accordingly. The question of where the money actually went is one that the guilty pleas and the sentencing did not fully answer. The figure of $8.5 to $10 million, and some reporting has placed the total even higher, represents what prosecutors could document and charge. It does not necessarily represent the ceiling of what was taken. Financial crimes of the kind Alex Murdaugh committed over 11 years leave accounting trails, but those trails exist within systems that were designed and maintained, in part, by the person doing the taking. The documented amounts reflect what investigators could establish to the legal standard required. The undocumented amounts, if they exist, are by definition harder to reach. Whether there were additional thefts that did not appear in the charging documents, whether there were financial structures that were never fully unravelled, whether the full scope of the fraud has been captured in any official record, these are questions to which the available record does not provide confident answers. And there is the harder question that sits behind all of the financial accounting. What did others know? PMPED, the law firm where Alex Murdaugh was a named partner, where he had practiced for decades, where his family name was on the door, who was also victimized by his theft. The CFO who confronted him on the morning of June 7th. 2021 had identified a missing $792,000. That confrontation is documented. What the record does not definitively establish is how long various people within the firm may have had access to information that should have raised questions, And what, if anything, was done with that information before the confrontation became unavoidable? Firms have accounting systems. They have oversight mechanisms. The question of how $792,000 in missing funds, or, at the outer range, $10 million across 11 years, moves through a law firm without triggering earlier formal action, is a question about institutional oversight that the criminal proceedings addressed only obliquely. South Carolina attorneys, in the aftermath of the case, acknowledged publicly that Alex Murdaugh had done serious harm to the legal profession in their state, and that acknowledgement was genuine, and it was significant, because it represented the profession confronting an uncomfortable self-assessment. But acknowledgement and structural reform are different things. Observers who watched the case closely noted the honest, if uncomfortable, reality. The system had not changed as much as it should have. The pressure generated by the Murdaugh case, the public scrutiny, the reform discussions, the attention to attorney oversight and client fund management, had produced some movement, but the structural vulnerabilities that allowed Alex Murdaugh to steal from clients for 11 years, while practicing law in a county where his family had generational influence, had not been fundamentally redesigned. The mechanisms that should have caught the fraud earlier, bar oversight, firm-level accounting controls, judicial proximity to a family whose conduct was never formally scrutinized, had not been rebuilt in ways that would reliably prevent their recurrence. This is the particular legacy the Murdaugh case leaves for the legal profession. Not just the story of a man who committed these specific crimes, but a documented demonstration of the conditions under which such crimes become possible and sustainable over time. The century of family dominance over the 14th Judicial Circuit was not incidental to the fraud. It was part of the architecture within which the fraud operated. Clients trusted Alex Murdaugh in part because of what the name meant, because of the weight of the institutional history that the name carried, because the social and professional landscape of Hampton and Colleton counties had been shaped in ways that made the Murdaugh name a form of collateral. When he exploited that trust, he was exploiting not just his individual professional position, but the accumulated credibility of an institution. And when the system failed to catch him for 11 years, it was failing in part because the ordinary mechanisms of professional accountability are not designed to operate at maximum efficiency against people for whom the surrounding institutional culture has created something close to professional immunity. The case is, in this documented sense, a stress test. Not a metaphorical one, a literal, empirically verifiable test of whether a legal system can hold itself accountable when the person whose conduct is at issue is embedded deeply enough in the system's own structures. The answer the Murdaugh case produced is partial and unsatisfying. Yes, eventually, after a murder investigation with international media attention, after body cam footage and a Snapchat video and a 28-day trial, after the weight of evidence became too heavy to manage through the ordinary lubricant of institutional deference, yes, eventually the system convicted him. But eventually is doing enormous work in that sentence. 11 years of financial crimes. 6 years since Stephen Smith's death before his case was reclassified. 3 years since Gloria Satterfield died before anyone formally examined whether the accident ruling warranted scrutiny. Eventually arrived. But it arrived late, and it arrived incompletely, and the path it travelled to get there was not a straight line. The 2 life sentences for murder, the 27 years for state fraud, the 40 years federal. These numbers represent the formal accounting of what the system concluded Alex Murdaugh had done and what it determined he owed. They are real consequences. They are, in a technical legal sense, justice. But they exist alongside a Rebecca Hill allegation that has not been fully adjudicated, alongside a 2-shooter argument that was rejected by a jury in 45 minutes, alongside a Stephen Smith investigation that is open and unresolved, alongside an accounting of stolen money that may not capture its full extent, alongside a law firm that produced a criminal of this magnitude over more than a decade, alongside a profession that says it was harmed and acknowledges it has not changed enough. What justice costs, in a case like this one, is not only what is sentenced, it is also the measure of what was allowed to persist, unchecked, for the years before justice arrived, and the honest acknowledgement of what remains unresolved after it did. Alex Murdaugh will die in prison. That is the verdict of the institutions he once moved through, with the confidence of a man who believed, with good reason based on available evidence, that those institutions would always make room for him. They did, for a very long time, and when they finally stopped making room, when the jury came back in 45 minutes and the judge read the sentence and the gavel came down, the closing of that chapter did not erase the length of the chapter that preceded it. It only marked where it ended. The tangled web is still partly tangled. The money has not been fully traced. The deaths have not all been answered. The reforms have not fully arrived. What the Murdaugh case produced finally was a conviction and a record, a public, permanent, legally established account of what one man did within a system that was supposed to prevent it. Whether the system that produced that record has learned enough from it to prevent the next version of the same story from taking 11 years to reach a courtroom is the question that the conviction, however just, cannot answer on its own.